You've probably been told you need asset protection, so you set up an LLC, the insurance, maybe even an irrevocable asset protection trust, and you think you're covered. Then a parent dies, the kids go to sell the real estate, and then they realize the protection plan just handed the IRS a massive check. I've seen families do everything right during life and still lose hundreds of thousands the moment the assets transfer because the trust was set up in a way that killed the step up in basis. In this video, I will show you the exact mistake that causes that surprise tax bill, how you can spot it in your estate plan, and what a better structure looks like. So the biggest loss in your family's plan doesn't happen quietly on the day, unfortunately, you pass away. I'm Talai, an asset protection and trust planning attorney and also a founder of Talai Law Offices, and today I want to explain why death is often the moment where asset protection plans are truly tested and why many families lose more at that single point than they ever would to a lawsuit. But before I continue, if you want to see how I structure asset protection plans for real estate investors here in California, including plans like LLCs and holding LLC strategies, trust, including irrevocable trust, and layered asset protection, I walk through all that in my free asset protection webinar, and you can register for this free webinar here at the link below, or if you like, you can go to my Instagram and DM me the word webinar, and I will have my office send you the live link. Now, let me share a story with you. A few months ago, a woman came to see me. Her father had just passed away. He was a careful man. He had an LLC for his rental properties. He had good insurance. He even had an irrevocable trust that his previous attorney set up years ago to protect against creditors. On paper, the plan looked solid. But when we sat down and looked at what actually happened when her father passed away, we found a problem nobody saw coming, because that irrevocable trust was structured as a completed gift transfer. The assets inside of this irrevocable trust were no longer part of the dad's taxable estate. And if he had estate tax problems, that would have been a good thing. But since he did not have large enough estate so that there would be any estate taxes, that just meant that his daughter did not receive a step up in basis on any of the assets inside the irrevocable trust. Her father purchased 3 rental properties in Los Angeles County over a span of 20 years. His original cost basis on those properties and adjusted cost basis combined they were about $900,000. At the time he passed away, those same properties were worth just about $4 million. When the daughter went to sell them, the capital gains tax bill came to roughly $1 million. $1 million in taxes that a different structure would have reduced to nothing, zero. Her father spent years protecting those assets from lawsuits, and he succeeded. Nobody ever took a dime from him in court, but the single largest loss his family ever experienced happened the day he unfortunately passed away, quietly, legally, and it could have been avoided entirely. Most people think the biggest asset protection risk happens while they're alive. They worry about lawsuits, they worry about creditors, they worry about tenants and partners and business risk, and those are all real concerns, and you should absolutely plan for them. But you gotta make sure that you plan properly. For many California families, the largest loss of wealth doesn't happen during life. It happens, unfortunately, at the time they pass away. All right, so here's the key idea I want you to understand. Asset protection is about controlling exposure, and death creates exposure that most people never planned for. When someone passes away, control shifts, assets move, rules change, and when assets move at the wrong time, in the wrong way, the tax system steps in. Let me explain this in plain English, because this is where it really matters. Many assets grow over decades: real estate, businesses, investment portfolios. The value goes up quietly year after year. The increase doesn't feel dangerous because there is no immediate tax while you're alive and you're holding on to the asset. But that gain is sitting there, waiting. And when an asset is transferred, whether it is sold, distributed, or restructured, the tax bill appears in most cases. And in California, with our high property values and our state income tax rate that goes up to 13.3% on top of the federal rate, the tax bill can be devastating. Now, what surprises a lot of people is that not all transfers are treated the same by the IRS. Some transfers dramatically reduce or eliminate tax exposures. When your children inherit property through a properly structured plan, they can receive what we call a step up in basis. The tax basis resets to the current fair market value at the time you pass away. Decades of appreciation wiped clean. No capital gains tax on the built-up gain. But other transfers lock that gain in and push the entire tax burden onto the next generation. And once that happens, there's no going back. You cannot undo this thing. If you don't like your kids, maybe you want to do something like that. Just give them one final gift. But I'm assuming if you're watching this video, that is not the case. The difference between those two outcomes that I just said is realistically the planning. You got to have the proper plan in place, and with the mindset that I want to do asset protection, but I also want to have proper income tax, proper capital gains tax planning built into the plan that I'm putting together for my family. Now, most families focus their estate plan on two things: avoiding probate and keeping assets out of their estate. And while those goals can be useful, they can also create a very dangerous blind spot. Because when assets are pushed out of your estate too aggressively or unnecessarily, they can lose access to powerful tax protection that only applies at death. This is where people get tripped up. They assume that out of the estate always means it's the safe choice, but it's not that way. Sometimes keeping assets out of your estate can provide estate tax planning and protection. And if you have a large estate north of $15 million, that could make sense. But for most California families whose estate are below that threshold, and keep in mind, if you're married, we're talking about $30 million, pushing assets out of the estate doesn't save them a dime in estate taxes because there are no estate taxes to pay or to save on paying them. But what it can do is expose the family to massive capital gains tax later on, because if those assets are not included in your estate at the time you pass away, your children do not get this a step up in basis. They inherit your original low-cost basis, and that trade-off is rarely explained to families. Unfortunately, I see this all the time in my practice. A client comes in with a plan that was set up 10 or 15 years ago, back when the estate tax exemption was much lower. Maybe it was an AB trust. Maybe it was a fully completed irrevocable trust. At the time, it made sense, but the law changed. The exemptions went up, and now that same plan is costing the family hundreds of thousands of dollars in capital gains taxes that didn't need to happen. And here's why I think this is an asset protection issue and not just a tax issue. When a family inherits assets with a large built-in gains, they often face impossible choices. Do we sell the property and pay the taxes now? Do we hold on to the property and carry the risk of being landlords when they don't want to be a landlord? Do we borrow against the property? Do we fight amongst ourselves over time? Those pressures forces decisions, and forced decisions destroy leverage. Just like in lawsuits, the party under pressure usually loses. If a creditor knows you have to sell the property, they have leverage over you. If the tax system forces your family to liquidate at a bad time, the result is exactly the same. Your family keeps less of what you have built. Let me give you an example. I had a family here in California where the parents passed away and left their 2 children a commercial property in San Diego. The property was worth about $2.5 million. The parents had transferred this particular property years earlier into an irrevocable trust to protect it from creditors. Great for lawsuit protection. It was a good trust for that purpose. But because it was a completed gift transfer, these children inherited the parents' original tax basis, which was about $400,000 when the parents passed away. One of the kids wanted to keep the property. The other one wanted to sell it. This is something that for some reason happens often. And they couldn't agree. That's something else that seems to happen often. And because selling would trigger over $700,000 in capital gains tax, neither one of them had a really good option at this point. Their dispute dragged on for over a year. It cost them a bunch of money in legal fees. It damaged their relationship. And ultimately, the property was sold at a time and a price that neither one of them really wanted. That is an asset protection failure, not because of a lawsuit, because the plan created pressure that didn't need it to exist. And that's the pattern you will see again and again. Rigid planning, unfortunately, breaks, and if you have a plan that is flexible, those are the type of plan that can adapt and could have a much better result for your family. Now, let me be clear about something. This does not mean that I'm saying everyone should pull all the assets back into their estate. It doesn't mean estate inclusion is always the right answer. It just means that if you have a plan that is unintentionally rigid, could be pretty dangerous. Asset protection is not about eliminating all the risk. That is not possible. It's about managing risk intelligently. And death is the moment when unmanaged risks show up all at once. In my practice, this is exactly why I often design what I call an incomplete irrevocable asset protection trust. It is a structure that provides a strong creditor protection during your lifetime, but because it's structured as an incomplete gift, the assets remain in your taxable estate, and that is the key. When those assets are included in the estate at the time you unfortunately pass away, your children will receive the full step-up in basis. They get the lawsuit protection while you're alive and the tax benefits when the assets are actually transferred, hopefully many years from now. That kind of flexibility is what separates planning that actually works from planning that looks good on paper but costs your family real money when it matters most. That is why you will hear experienced planners talk less about specific tools and more about control. Because control equals leverage, and leverage is what protects families when circumstances change, when laws change, and when the unexpected happens. So if you take one thing from this video, remember this: the biggest asset protection planning risk for many California families doesn't show up in a courtroom. It shows up at death when assets move and pressure appears from directions nobody expected. If your plan only works when everything goes exactly as expected, that is not protection. That is a gamble, and your family deserves better than that. Now, if this is making you think differently about asset protection, good. That is the point. Because most people think asset protection is only about lawsuits and creditors. And that's only part of the picture. In my video, asset protection isn't just about lawsuits anymore. I break down exactly why the biggest threat to many families has nothing to do with a courtroom and everything to do with how the tax system treats your assets when they change hands. If you haven't seen that video yet, I would encourage you to go watch it because it lays the foundation for everything we talked about today. I look forward to seeing you over there.